Hello and welcome to this IndiaLaw LLP podcast. I'm Nikita, Dlima, and today I'm joined by Mr. Rahul Sundaram to discuss an important decision of the Bombay High Court in Aditya Birla Housing Finance Limited versus Axis Bank Limited and others. The judgment examines a practical question in lending transactions. When a loan takeover does not go smoothly because title documents are not released, can the dispute be sent to arbitration under Section 11 of the SARFAESI Act? Rahul, welcome.
Thank you, Nikita. This is a very relevant decision because it looks at the intersection of loan takeover transaction, security creation, title document custody, contractual arbitration, and statutory arbitration under the SARFAESI Act. The court was not simply deciding on a routine appointment under Section 11 of the Arbitration Act, appointment of an arbitrator. It was deciding whether a financial institution which had not yet become a secured creditor because the title documents were withheld could still invoke statutory arbitration against the bank already holding the security.
Let us begin with a factual background. What exactly happened between Aditya Birla Housing Finance, Axis Bank, and the borrowers?
Sure. The borrower had existing cash credit and overdraft facility with Axis Bank, and they then approached Aditya Birla Housing Finance for credit facility of about 4.7 crores. The purpose of the new facility was to take over the borrower's existing cash credit and overdraft facility, which was running with Axis Bank. The property involved was one situated in southwest Delhi, which I think in Dwarka, which had been mortgaged. Aditya Birla was to pay about 1.1 crore directly into the cash credit account of Axis Bank, and there were certain delays which were there.
So Aditya Birla paid the outstanding amount to Axis Bank. Then why did the dispute arise?
The dispute arose because there was a time gap between the foreclosure statement and the actual credit of funds. Because of this gap, a small balance of about 2.3 lakh remained outstanding in the overall account. Axis Bank therefore did not close the account and did not hand over the original title documents to Aditya Birla. Aditya Birla's case was that Axis Bank knew this was a loan takeover and should have asked for the small remaining amount instead of keeping the security alive by not returning the documents. Matters became more complicated when the debit freeze of the overdraft account was later lifted and the borrower allegedly started drawing further from the cash credit account.
What steps did Aditya Birla take before approaching the court under Section 11?
Sure. So Aditya Birla filed a petition under Section 9 of the Arbitration Conciliation Act, an interim application for interim relief to proceed. The court directed Axis Bank to deposit the title deed in the registry of the court. And of course, the interim relief was to seek protection of the title papers. The court directed that the title deeds should remain deposited during the pendency of the arbitral proceedings, but it left open the questions whether the dispute between Aditya Birla and Axis Bank was arbitrable. After that, Aditya Birla invoked arbitration. Axis Bank replied that there was no contractual relationship and no arbitration agreement between it and Aditya Birla. That is how the Section 11 application came before the Bombay High Court.
What was Aditya Birla's main legal argument?
Aditya Birla argued that this was an internal creditor dispute between a financial institution and a bank. It said that Section 11 of the SARFAESI Act, this is not the Arbitration Act, the SARFAESI Act created a statutory route for arbitration where disputes related to securitization, reconstruction, or non-payment of amounts due arising among banks, financial institutions, asset reconstruction companies, or qualified buyers, any of these disputes could be referred to arbitration, a statutory arbitration, even if there is no written agreement. Aditya Birla also relied on the loan documentation and power of attorney executed by the borrower and submitted that it had at least a charge or enforceable interest that should have matured into security once the Axis Bank released the title documents.
And what was Axis Bank's response to this?
Axis Bank opposed the reference. Its main submission was that Aditya Birla was not a secured creditor because no security interest was created. The original title papers were yet with Axis Bank, and argued that SARFAESI Act is meant for secured creditors and that Section 11 cannot be used by an unsecured lender. Axis Bank also argued that there was no privity of contract and no written arbitration agreement between Axis Bank and Aditya Birla. According to Axis Bank, Aditya Birla's remedy, if any, was against the borrower under the said loan agreement.
And what issue did the Bombay High Court frame for itself in substance?
Sure. The core issues was whether the arbitration could be conducted between Aditya Birla and Axis Bank and Section 11 of the under Section 11 of the SARFAESI Act, even though Aditya Birla was prevented from becoming a secured creditor because Axis Bank had not handed over the title documents. The court also had to consider whether the contractual arbitration clause between Aditya Birla and the borrower could proceed along with the statutory arbitration reference under Section 11 of the SARFAESI Act against Axis Bank.
How did the court interpret Section 11 of the SARFAESI Act?
Sure. The court focused on the language of Section 11. It noted that the provision applies where a dispute arises among a bank, a financial institution, asset reconstruction company, or a qualified buyer, and when the dispute relates to securitization, reconstruction, or non-payment of any amounts due, including interest. The court observed that Section 11 itself does not use the expression secured creditor. Therefore, on the plain text of the provisions, the court was not prepared to accept that a bank or a financial institution must already be a secured creditor before invoking Section 11 of the SARFAESI Act.
Did the court accept Axis Bank's reliance on the arguments that SARFAESI applies only to secured creditors?
No, not in the context of Section 11. The court distinguished cases dealing with enforcement under Section 13 and 14 of the SARFAESI Act, where creation of security interest is essential. Here, Aditya Birla was not seeking to enforce security interest. Section 13 of under Section 13 or 14, it was seeking a statutory arbitration reference against Axis Bank because its ability to become a secured creditor was blocked by Axis Bank's refusal to release title documents. The court therefore held that these enforcement-related authorities did not answer the specific questions before the court.
There was also a Calcutta High Court decision involving Reliance Commercial Finance and Axis Bank. How did that feature in the reasoning?
The Bombay High Court noted that the Calcutta High Court had dealt with broadly similar facts where a financial institution had taken over a loan and sought title documents from Axis Bank Limited. There, in that case, it was Reliance. The Calcutta High Court had observed that Section 11 of the SARFAESI Act created a statutory fiction of an arbitration agreement. So a separate written arbitration agreement as defined under Section 7 of the Arbitration Act may not be necessary if the statutory conditions are satisfied. The Bombay High Court did not rely on that case as determinative, but found the broader reasoning consistent with its own interpretation.
What did the court ultimately hold on arbitrability?
Sure. The court held that the dispute between Aditya Birla and Axis Bank was triggered by the borrower's non-payment to both the entities, Axis Bank And Axis Bank was refusing to release the title deeds because it wanted to recover its own dues from the same borrower. Therefore, the dispute fell within the expression non-payment of any amount due, including interest, under Section 11 of the SARFAESI Act. The court concluded that the dispute between Aditya Birla and Axis Bank must be resolved through statutory arbitration under Section 11.
What about the borrowers? Were they also brought into arbitration?
The loan agreement between Aditya Birla and the borrower had an arbitration clause which very clearly required any disputes to be referred to arbitration at Mumbai. The court found that there was no serious dispute about arbitrability between Aditya Birla and the borrower. The more difficult question was on Axis Bank. The court held that common arbitration could be conducted, contractual arbitration against the borrower and statutory arbitration against Axis Bank. It was reasoned that having the same arbitral tribunal decide both contractual dispute, both connected disputes, contractual and statutory, would be more efficient and would avoid fragmented proceedings.
Did the court say that Axis Bank would be stopped from enforcing its own SARFAESI remedies?
No, the court was careful on this point. It expressly noted that Axis Bank would remain free to take measures against the borrower under Section 13 and 14 of the SARFAESI Act. The pendency of the Section 11 arbitration reference would not impede Axis Bank's recovery action. In other words, the arbitration would decide the inter se dispute, but would not freeze Axis Bank's statutory recovery rights per se.
What is the larger legal significance of this judgment?
The judgment is significant for three reasons. First, it recognizes that Section 11 of the SARFAESI Act may cover more than classic priority disputes between two secured creditors. Second, it clarifies that a financial institution blocked from becoming a secured creditor due to withholding of the title documents may still be able to seek statutory arbitration where the dispute is connected to non-payment by the same borrower. Thirdly, it shows that courts may permit a combined arbitral reference where a contractual arbitration against the borrower and a statutory arbitration against another financial institution or bank are closely connected or interlinked in that manner.
From a lending and documentation perspective, what should banks and housing finance companies take away from this judgment?
That's a very good question. The practical takeaway is that loan takeover transactions must be documented and coordinated very carefully. Foreclosure amounts should be updated up to the actual date of payment, and this discrepancies should not arise which lead to such dispute like in this case. If there is a gap, the parties should account for interest and incidental charges. Debit freeze, release of the title deeds, closure confirmation and transfer of security documents should be handed through clearly written communication. This case shows how a small outstanding amount can lead to a much larger dispute involving the document's security interest and arbitration.
Before we close, could you summarize the outcome in one line?
Sure. The Bombay High Court allowed the reference to arbitration, holding that the connected dispute among Aditya Birla, Axis Bank and the borrower could be referred to a common arbitral process, common arbitral tribunal, with Aditya Birla proceeding contractually against the borrower and statutorily against Axis Bank under Section 11 of the SARFAESI Act.
Thank you, Rahul. This decision is a useful reminder that in loan takeovers, the real issue is not only repayment but also the transfer of security. When title documents remain stuck between lenders, the law may step in to create a structured dispute resolution route. This brings us to the end of the podcast. Thank you for listening. For more legal updates and practical insights, stay connected with India Law LLP.